to now introduce to you Joan Fox, who is an administrator of housing supports and self-sufficiency at DuPage County Community Services. Joan has been working with our program to help us develop a way to connect landlords and tenants to financial resources that are available to them. All mediation participants who will have been referred to community services prior to mediation. And Joan is with us today to give us that background on financial resources on eviction prevention. Thank you, Joan.
Thank you, Kimberly. Can you hear me okay?
Yes.
Great. I was having some problems earlier with my sound. So thank you for having me here. We're really excited to be a part of this amazing project that you have going on. I'm Joan Fox. I'm from DuPage County Community Services, Housing Support and Self-Sufficiency. I've been providing homelessness prevention services in DuPage County for many years. I work in a larger group, so DuPage County Community Services will apply for and receive funding from a variety of state, local, and federal sources in order to bring that to the county and help people who've had an economic crisis recover and not lose their housing. We also have a variety of services that we can help families with moving forward so that they can continue on with their rent. So today I'm just going to focus primarily on our court-based services, which is new, and that's providing financial assistance and supportive services to resolve and prevent evictions. Can I have the next slide, please? Okay, so the first thing I want to talk about is, as been mentioned here is that the resources available right now are really off the charts in terms of what we've had available in the past. And specifically, the U.S. Treasury has given 2 phases of funds through the Emergency Rental Assistance Fund program, and they call it ERAP, like the Emergency Rental Assistance Program. It is one of the largest housing rent assistance payments that was created for this purpose. There is $46 billion nationwide. And in Illinois, these funds came to both certain localities, like DuPage County received some funds, Lake County, Cook County received funds, and funds also went to the state. And they resulted in the following programs. So we have the Illinois Rental Payment Program, which is offered through IDA. That's the portal that opened last May and had both a landlord-initiated application and a tenant-initiated application. They're still working through the Department of Illinois Human Services on an emergency rental assistance program, which is offered statewide through not-for-profit agencies. So that's a way that portal in some ways continues. And then finally, they're having an Illinois court-based rental assistance program, which is a collaborative effort, and that just began last week. So there's $60 million that's put into this program to help people who might have fallen through the cracks in either of those other programs and are still at risk of eviction. Can I have the next slide? So I just want to say that so far, we know that with the eviction moratorium, their tenants were getting behind very far on their rent, and landlords were also in distress. So the Illinois Rental Payment Program has offered a large amount of money and has been really successful in resolving those rent arrearages. So in DuPage County, we probably have about $10 million that are in applications that are still going through that program, but $15 million have been distributed to our agencies and landlords. 345 million have been distributed statewide. So we've done a lot to help this project. So next slide, please. Just so people know that Illinois is one of the few states with some eviction protection currently in place with that eviction moratorium, which is soon to end. Next slide, please. So just want to tell you about the Illinois Court-Based Rental Assistance Program. It will be available to provide financial assistance to households who are in eviction because they fell behind on their rent, they lost income, or suffered financial hardship due to COVID-19, and they are at risk of homelessness or housing instability. The program is available only to households where an eviction has been initiated. So as in the past, we had the portal that was available to everyone. Currently, this program is only available to households where there's an eviction. The tenant needs to initiate an application at this link below, which has been distributed, but really is only for individuals who are in court. People can apply for 12 months back rent and 3 months future rent from the date of application. I think it's important to note that because I mentioned all of the different programs that are coming through these treasury funds, that the statutory limits apply. So you can't just like get 12 months from this program, 12 months from the next program, and then 12 months from another. You really need to continue to apply to the statutes, which is right there, 12 months. Next slide, please. DuPage County Community Services is dedicating case management support in the courts. So what we'll do is support tenants and landlords to submit quality applications to the court-based rental assistance program portal. We'll be able to answer questions about that. We'll work with Kimberly and Alyssa and the Mediation Center to help people update and upload their documents and understand the documents that will help them secure that assistance. Then we'll also be able to work in partnership with IDA to communicate directly to the courts regarding the status of financial assistance. And then I think what's also important is where people are not eligible for these funds or where this court-based rental assistance program can't exist, DuPage County Community Services may be able to assist with other grants or other funds that we have. For example, court cost fees are a huge thing that this program doesn't cover. We might be able to help with a limited amount of those court cost fees as somebody goes through that. Next slide, please. So I just want to say that I know eviction is a legal process. You have tenants, you have landlords who obviously both have rights in what they're having, but just and our goal is really to prevent an eviction from occurring. An eviction does have a long-term effect on the families who have received it. Currently, the governor's order seals these evictions, so that will help in some ways, but there's a lot of different impacts that people will have with the evictions. And next slide, please. So some of the impacts of eviction obviously can include loss of your home, loss of possessions, because people might not have a place to go immediately. They might need to lose some of their possessions. It's a loss of connection to the community. Children have to switch schools. The court records, of course, can impact. We've just heard a big presentation about how judgments can impact the family. And then also eviction can affect the mental health and may lead to job loss. So just kind of in this program, I want to know that obviously all of our services are designed to stabilize individuals in their existing homes. When needed, we can assist individuals and families to make that housing affordable. And we might be able to assist with securing new permanent housing if that's necessary. Next slide, please. We also have a wealth of other services. So our case managers can work both to resolve the immediate needs of an eviction and to connect households with a wealth of helpful other services to aid households in maintaining their housing, accessing mainstream services such as the LIHEAP program, food stamps, Medicaid, counseling, case management support, other sorts of things like that. And our goal is to help families increase their income and achieve their goals with these ongoing programs. So we mentioned about this program being in the courts, and we're really excited to be here. And within the courts, we've been working with Kimberly, and I know that Ron Soika and Prairie State Legal Services have really worked towards getting as far upstream as possible to let people know that services are available. But as you're working with the landlords, we also want to let you know that we have services before you can get to eviction. So obviously not the counselor in the court. I think we'll be sufficiently busy with the incoming here, but there's a lot of agencies throughout the county that can help with individuals who are behind on their rent or may become behind on their rent. So in the beginning, somebody mentioned something that tenants might tell their landlords, like, I've lost my job is reducing the number of hours, I am getting sick, I'm going to be going to the doctor, I'm not sure if I'm going to be able to pay my next rent, right? I might be going through a divorce or another sort of change in family composition. At that time, it's a really good time for the tenant to reach out to other services. We might not come in with any sort of financial assistance, but we might be able to come in with other types of support that help direct that person's resources towards their rent and towards their housing. So the farthest upstream we can get, the better. So within the, we have an agency organization called the DuPage Continuum of Care. That's a national structure that offered through HUD, and our goal is to end homelessness within our communities. But mostly what we'll do is help with emergency shelter, transitional housing, permanent supportive housing. And we have a wealth of agencies who work together to provide housing stability services and distribute an array of funding. We do that either by target population. So some places might just deal with youth, or they might help with seniors. Prairie State Legal Services, a part of our team, they work with providing legal services. We may cut up our areas to distribute the same funding in different geographies. So Catholic Charities can serve the east side of the county, where the DuPage County Community Services might serve the west side of the county, where we have similar funds. Our case managers can help tenants access services from all of these agencies. So our case managers, just like you guys kind of know each other, we know each other as well. So we know, like, when Loaves and Fishes can come in with a charitable resource. We know if Catholic Charities might be able to help somebody through their immigration program. We know the importance that Outreach Communities has in the Carroll Stream area. People's Resource Center with food assistance, employment assistance, computer training, all of those sorts of things. So our case managers are used to working with the other agencies and coordinating services to help get your tenant back to the best situation they can be in. Next slide, please. If people are interested in learning more about the resources that are available throughout DuPage, we do have an online community resource information system. So you can actually call us and talk to a live operator. An information and referral specialist is there to answer anyone's questions about resources that might be available in the community. Or you can look on your own at www.dupagechris.org. That's going to be our community resource information system. And you can look for things like clothing, houseware, education, health and well-being. It's always a great referral to give to anyone who's maybe in need of some social services, even for a short period of time. Again, the sooner that people can get involved with our agencies, the better that would be. And I think that brings us to the end. So again, if you have any questions or you wanted to contact us, you can call us, contact us using this email below, housing@dupageco.org. That gets to myself, that will get to my manager and my unit and the case managers that she supervises. So we can generally answer any questions that you have there.
Thank you so much, Joan. We actually have a question for you.
Okay.
The question is, with the Illinois Rental Assistance Program, once the tenant applies for rental assistance and is approved, does the money go directly to the tenant, who in turn pays the landlord, or does the rent money go directly by direct deposit to the landlord once the tenant has applied?
So as I said, there's like 3 different programs going on right now. With a tenant-led application, I think there are possibilities that some of the checks will go to a tenant, and then the tenant is either supposed to use that to get to the landlord. But that is for applications where the landlord did not participate. So I think those are probably few and far between. In this program, it's kind of broken up. You're applying through the portal. The tenant will initiate it. The landlord will complete the application, and so the landlord can provide their direct deposit. There is a system that they have to be in order to get a direct deposit. Otherwise, it's going to be through the mail.
Okay, thank you. Let's see, as a follow-up to that question, if the rent money goes directly to the landlord by direct deposit, once the tenant has applied and the landlord does not get it from the government, whose responsibility, tenant or landlord, to follow up as to what happened? If the landlord never got the money, can the landlord sue for the tenant for non-payment? You probably can't answer that second half, but.
Yeah, it's a little complicated because I think you're going to have to go back to the individual or the entity that's providing that check. So we can work with the Illinois Housing Development Authority to follow up on the status of any sort of payment. I think if these payments have been fairly large, I think the average is about $9,000 in assistance for that ILREP program. That was, so not getting that check would be pretty important to follow up on. And then I don't know what you can do as far as a legal remedy.
Yeah. Another question is, an undocumented parent of children who are American citizens able to access any of the rental assistance programs, or does their status preclude their ability to apply?
That's a great question. And we're not asking any questions regarding citizenship or residency in this program. If there's other types of programs that they're looking into, like moving forward, residency might become into an issue, but we can talk to the families about that.
Okay. Ted Donner asked a question that I can answer. His question is there a number who we could call actually during a mediation where there would be someone readily available? We're going to get to that in the program logistics, but it does make sense to talk about right now, which is that we have the mediation center, the Eviction Mediation Program has partnered with, Prairie State Legal Services and with community services, so that all tenants and landlords will get referrals to services at the moment they're ordered to mediation, and they mediate within the next 28 days and towards the end of that 28 days, so that ideally they will have these resources to have that worked out before they get to mediation, or at least know what's happening. Let's say if not, and we're in the middle of a mediation and we need to know some answers, our office is communicating with Joan's office to be able to get information so that we can answer that question for you. So all our mediators will have to do is just ask the mediation center ourselves, and we can pull up the background on that case, and ideally be able to prep the mediator beforehand. They mediate, this is what you need to know about this case to mediate it. But if something comes up on the spot. That's why we have a program coordinator, Alyssa Fortino. She has started, she formerly worked with Joan in community services and has an excellent background to how that works. And I think will be a great resolution to those questions that come up for our mediators. Another question that came up that perhaps our other panelists who spoke earlier could answer, and if not, at this point, we'll get an answer for this person in the typed out, but if any of our presenters want to turn their camera on and answer it, the question is, are eviction solutions going to follow a family like a bankruptcy affects credit ratings? And if so, how long? So I think they're probably wondering, are there types of agreements that people might be reaching in mediation that really follow them for the long haul? Like, for example, perhaps losing that Section 8 certificate. If any of our former presenters want to turn their screens back on and answer that. David, thank you.
Yeah, I can answer that personally. I think right now, all eviction files are sealed when they're filed. And that's a new statute from, gosh, I think it came into effect maybe earlier this year or late last year. What happens, but I think that provision sunsets in like 2022. So I don't know that they'll be sealed forever. Judgments have in the past certainly become a matter of a public record search. So yes, it can definitely impact, somebody's credit history going forward. I think for like a housing choice voucher, you certainly want to avoid, if possible, the entry of a judgment because it'll impact your eligibility for that voucher. So some sort of dismissal of the action would typically be a better resolution if there was a way to work it out with the landlord. If you can set up a payment arrangement, sometimes you can even, if it's not going to be possible, a payment arrangement, maybe an agreed out move out date with the dismissal of the case, it's still possible it will end up in collection. But as the eviction process, it's better, the dismissal is probably better in terms of kind of long-term. Although, as I said, now eviction files are sealed, but I think that only goes through 2022.
Yeah, I think April 2022 at this point. I don't know but exactly. And then the sort of follow-up to that is the question was asked, if the file is sealed, can the attorneys of record access the file online? And yes, that statute has exceptions for who can see the file. It would be the attorney of record, prospective counsel, government or public employees charged with processing the eviction. So you have to file your appearance to do that. And you can reach out to the clerk's office if you have problems with e-access, which is our, anyone else have anything to say on that question?
Well, I know it's challenging to get access. It's become much more difficult to get file information. I know certain information is available through e-access, but just generally getting information through like Odyssey is a bit more complicated of getting copy of the order. I don't know, Ron or Patrick, any thoughts about?
Actually, when you go on the system that you normally like put your orders in there, there's one of the boxes talks about asking for access. Usually I just put in the case number and I put in there that I'm attorney for plaintiff and I get it by the next day. Then I have access from that day forward. I thought it was going to be hard, but it turned out to be pretty quick. Now, the problem is if a client comes in on a pending case and you want to look it up, you can't do that. But once you are in the case or you're already in it, you just put in the case number, you ask for the access, and they get back. Literally, they've been back to me every day. The next day, I think 3 times I've done it in the last few weeks.
Is that through e-access then, or?
E-access, yes. It's one of the, you know how they have like a row of boxes is the bottom middle, I think,
Yeah.
or something.
Okay.
Yeah.
As you can see too, it brings up such a good point that everything in this area is just constantly changing with the eviction moratorium and new statutes coming out. So these are good questions.
I mean, that's definitely been the past 19 months is pretty much daily, weekly, monthly, lots of changes.
Yeah.
Hard to keep
Another-
up with them all.
For sure. Another good question, under the governor's order, all evictions are sealed, but what happens when the landlord hires Pat to collect the judgment? The case isn't sealed, is it? My point being that the sealed nature of eviction cases doesn't really last much longer than 30 days if the landlord tries to collect on the judgment.
Correct. That is the one thing. It'll be sealed in the sense nobody else can look it up. But obviously, if you get you can record a certified copy of the judgment in the recorder's office. There's nothing that prohibits that. You can get a memorandum and record it. But that's not done too often because most people don't own real estate anyway that are renting and getting evicted. So, but the clerk's restricted information system, the one where you enter your orders, it has requests for special permission. You click on it, you put the case number, you put the reason for the request and hit submit, and boom, I usually get it back the next day. Sorry, I was looking it up when you guys were talking.
And I would just point out that all residential eviction actions filed between March 9th, 2020 and March 31st, 2022 must be sealed. So those are the dates for sealing.
Thank you, Ron.
Thanks, Ron.
Someone asked a question in the chat, and if anyone else has any questions, we actually have 4 minutes back in our schedule now. The question is, does mediation help landlords as they seek to recover past rent, or only agree to what tenant agrees as they do not have money to pay?
Obviously, if they don't have money to pay, it's not going to matter. They just don't have it. But like I said, you can actually have, if they want to make a payment plan, I mean, of course, they just can't come up with $7,000. Not too many people can. They're in eviction court. But you can set up to where they agree to pay $5,000 at $100 a month, dismissing with leave to reinstate. But if they default, you reinstate and enter judgment for $7,000 less payments made. That's what I was giving as an example where the tenant avoids the judgment, but the landlord has some motivation for the tenant to pay with where they can motion up to reinstate and enter judgment for a little bit higher amount to motivate a tenant. But sometimes you just ask for a consent judgment, hoping that someone changes their lives around later. You just give them a discount. I just did that today. I put in the order that my client is seeking approximately $15,000. The defendant told me he has no money. My client admitted the odds of him ever getting a real good job was minimal. So he agreed to a consent judgment of $11,000. Not that my client will ever hire me to collect, but hey, we have the judgment out there if something ever changes down the road.
Yeah. Someone asked an anonymous question, and I can't remember what their first question was. Perhaps other people on the panel could. They said, to clarify, I'm thinking about bank officers making judgments to extend a lease or any other kind of large loan for those having this history, however long ago, even if remedied. I think that was probably connected to a question about cases that were impounded or sealed. Is that, if you want to clarify your question a little bit, we could answer it for you. We'll give that person a moment. Any other questions before we move on? The next section, we are going to have Denise and join me. And if any of our panelists have things that come up while we're in this session that they think are good tidbits, feel free to add in. For 45 minutes, we're going to go into talking about giving the mediators on this call an example of how to mediate an eviction case and the things you should consider and types of questions you'll be asking. And looks like all of our questions were answered live. So great. Now I'm going to have asked Denise to join me in presenting our next session, which is, again, mediating an eviction case. At this point, I'm going to share your screen. So I won't be able to see any questions that are asked during this time, but we'll get to them eventually. So. Okay, Denise, thanks for joining me.
Thanks, Kim. Hi, I'm Denise Bezic. I'm one of the attorneys at Prairie State Legal Services, and I work with Ron Soika, mostly in eviction court in DuPage County. Prairie State Legal Services has a courthouse-based eviction project, and we are in eviction court every morning and some afternoons as well to talk to tenants who qualify for our services about their options in eviction court. we've been doing this for years in eviction court in DuPage County, and we're going to continue doing this as the mediation program gets underway. For mediators on this call, I want you to know that because there have been some questions, that tenants will have an opportunity when they first come to eviction court at the first return date that Ron and David talked about earlier, to meet with an attorney from Prairie State Legal Services or one of our support staff people to fill out an application for free legal advice and to eventually meet with one of us if they qualify. So we're hoping to be able to meet with tenants who qualify for our services to help them understand what their legal rights are before they get to mediation. We've also been working with Joan Fox from DuPage Community Services to make sure that her staff has the ability to refer people to us if they haven't made it to us by the time they're talking to her about rental assistance. And we are working to refer people to Joanne's program if they make it to us before they talk to Joan's program about rental assistance. So in this session, we want to talk about identifying the parties' interests. Kim is going to talk to you later in the session specifically in working with self-represented litigants. Self-represented litigants are either plaintiff landlords who are handling their cases on their own without the assistance of an attorney, or defendant tenants who do not have an attorney representing them in court. One of the topics that Kim will be addressing is time-effective mediation. She will talk to you about a timeline for how to manage the time within the mediation in order to in order to have all of the parties be heard and hopefully get to a resolution. And then finally, how to memorialize the agreements in writing. Next slide. There's a difference between the parties' rights and the parties' interest. The rights are drawn from the lease and the lease agreement between the tenant and the landlord and landlord-tenant law. Ron and David talked to you about landlord-tenant law and the tenant rights and the landlord rights. But when the parties get to mediation, what the mediators should be looking at are the parties' interests, which are in part related to their rights, but also drawn from their more personal and practical considerations. So a successful mediator would shift the focus from the court process of the adjudicated legal rights to the interest of the parties, because really it's their interest that is going to, addressing their interest is going to best lead them to a mediated result. Do you have anything to add there, Kim?
No, I think you hit it spot on.
Okay, and I do want to sort of express a caveat here. I'm a lawyer. I work for Prairie State Legal Services. I have many years' experience in talking to people who are in crisis about their very difficult situations and sort of honing down their personal interest and then helping them understand their legal rights. Kim is the experienced mediator in this conversation, so she's going to be joining in and adding specific tips for mediating these problems.
Thanks.
So these are sort of, Kim had produced this slide to give mediators on this training an idea of what the typical party interests are in the landlord-tenant relationship. There are a couple of different types of landlords, but I think that we would all agree that there are two, predominant groups of landlords. The larger, more corporate landlords, a corporation that owns a large apartment complex or several large apartment complexes, and then the smaller, more mom and pop operations where one, individual landlord might own one property or a couple of properties, and the landlord interest may differ in those two situations. Of course, there's a variety of landlords that are in between those two poles, but that kind of gives you an idea to think about which types of landlords you are helping to mediate. Landlords typically are looking for stable rental income, especially the smaller landlords that may be depending on rental income to pay the mortgage and taxes on the property where the tenant is renting. The landlords are looking to pay off their mortgage and their property taxes. If there's a non-paying tenant or a tenant who is causing problems in the property, the landlords definitely have an interest in replacing that tenant with somebody who is more reliable from the landlord's perspective. The court process can be long and expensive. So landlords are often looking for a cost-effective and quicker resolution to their problems. Tenants, on the other hand, they're thinking about shelter. They're thinking about, this is the place that is their home. And if they're evicted from this home, everything that, that has to do with changing your home is involved in the tenant situation. Moving, the cost of a moving truck, how to get the furniture out of the apartment. Think of a senior citizen who would have to, who's lived someplace for 10 years and would have to find somebody to help them carry their heavy furniture down 3 flights of stairs. This is, the place where they have safety, their family's secure, and there's dignity associated with your home. And tenants are literally facing homelessness in many situations when they are in eviction court. They're also struggling, especially, post-COVID, or let's hope that this is post-COVID, to stay financially afloat. People have had really difficult time in many situations maintaining their income. A lot of people live paycheck to paycheck, don't have a lot of money in savings. And when they've had to, remember way back at the beginning, their factory shut down, or they were a food service worker and the restaurant where they worked closed, they lost income for that period of time. It was a while before people could get unemployment going. And then even people who were back to work have over time had to stop working, either because they had COVID or the person they worked next to had COVID and they had to quarantine as a close associate of that person, close contact of that person. So people have had a really difficult time during the COVID crisis in staying financially afloat, because they've had, in some cases, not all cases, but in some cases, periods of sudden reduction of income or sudden loss of income, even if those periods were just for a few weeks at a time. When you're living paycheck to paycheck, losing 2 weeks of pay really makes it difficult to keep up on your rent. And then, moving forward makes it difficult to catch up on what you've gotten behind on. Several of the presenters have talked about the issue with Section 8 or other types of publicly assisted housing. An eviction could mean the inability to keep a government subsidy or obtain a government subsidy in the future for housing. Right now, and this may change, as the moratorium ends, but right now, the Illinois eviction moratorium, the last sort of portion of it prevents the sheriff from enforcing eviction orders that were issued through the courts through October 3rd. So the eviction moratorium has been in place since way back at the beginning of the moratorium in the spring of the COVID crisis in the spring of 2020. There hasn't been as much movement of tenants in the housing market as in previous times. And it's very difficult right now for even tenants who have money to find a new place to live. So the landlords are frustrated because they have tenants who maybe are not paying full rent or haven't paid any rent during the COVID crisis, and they can't get them out. And the tenants are frustrated because even the ones who have money to pay can't find a new place to live. Communication between these parties may hopefully result in a prevention of homelessness, maybe some decisions that people, with the help of rental assistance, can stay where they are if they were good tenants to begin with. And if they're not going to stay where they are, might facilitate a quicker resolution for people moving on and the landlords getting the possession of their property back, so that that property then is available to rent to somebody else. Anything else, Kim?
No, I think you nailed it.
So Kim has put some questions here to help identify the interest of the parties. And we're starting with questions that you might ask a landlord. When you're mediating a case, you want to know the position that each party is coming from, and their interest and their goals in the mediation in order to get to a resolution. So you might start by asking the landlord questions related to the number of rental units, how many properties they currently own, because the answers to these questions might make a difference in what their goals are in the mediation. It's good to know if the landlord and the tenant have attempted to settle the matter outside of court, and if not, why. Now, this is an unusual time because, as I said, tenants and pre-COVID, if a tenant didn't pay rent for a month or maybe 2 months, the landlord might start an eviction process and get into court fairly quickly. And the amount of money that the tenant owes is a month or 2 or 3 months of rent. Now, tenants have been in the properties sometimes for 10 months or more and behind on the rent. And so there may have been efforts to settle the case and make payment arrangements or settle the case. And if those haven't been fruitful, now tempers, maybe tempers is a bad word, emotions might be running really high, and it's good for the mediator to know that going in. If there are problems related to the acceptability of the tenant, and those problems can't be resolved, that's good to know at the beginning of the mediation process as well, because the mediator will understand that, sort of a pay and stay arrangement maybe isn't an arrangement that a landlord is looking to accept. Anything else that you would want to add, Kim?
No, I think that's great too. And, what is it that they want to achieve from this mediation can help you figure out from the beginning if the person's pretty shut down to even talking and figuring out if they can reach an agreement, or, if they really want to be able to get something out of this. And you can just know as a mediator and planning ahead on your, how you think you want to approach it. Is this person shut off? How shut off are they? Where are they shut off? Or are they really coming to the table today wanting to get an agreement? There's a next slide, Denise.
So something to think about in talking to the tenants. It might be very difficult for a tenant who's coming to mediation to kind of express the heart of what their problem is. It can be embarrassing to not have been able to pay the rent. People are feeling, in some cases, like they are not able to support their children. And so I would say a mediator should think about asking questions in a variety of different ways and being sensitive to the fact that a tenant might not immediately feel comfortable sharing sort of the root of what their problem is. But from the tenant's perspective, it's also good to know whether the tenant and the landlord have attempted to settle the matter outside of court, and why or why not. In some situations, you might find that a tenant has wanted to or tried to make some payments that the landlord hasn't accepted for a variety of reasons. Sometimes if, and sort of in pre-COVID world, if a landlord gave a 5-day notice and the tenant didn't pay within the 5 days, many times a landlord would simply not accept any more payments because the case was going to court. And if a landlord gave a 30-day notice to terminate a month-to-month tenancy, the landlord didn't want to then accept payments and reestablish that tenancy. So there may be some legal reasons or some personal reasons why a landlord hasn't accepted a payment or why a tenant hasn't offered a payment. And that's good to know at the beginning, because maybe that's not a final decision on either part. There may be some reasons that they might be able to explain to the mediator why they haven't been able to reach that resolution to this point. In addition, as Joan Fox explained, there is a lot of rental assistance available now to tenants, and the types of rental assistance and the application process for each type of assistance sort of pops up without a lot of notice. So a tenant might come in and say, well, I didn't apply for the IDA money because the deadline had passed. Well, there's a brand new IDA program that's available through the courts that the tenant, might not have thought of. It's also important to know from the tenant's perspective, aside from the current dispute over rent, what the relationship has been with the landlord and property management. In some cases, a tenant might say, I didn't pay rent because I had a problem with the condition at the property and I've been asking for it to be repaired and the property has not been repaired. Remember, we talked about whether that's a legal defense and how to launch that legal defense in Ron and David's presentation. But now when we're talking about what the interests are, if the tenant has the money to catch up on the rent and the landlord is willing to make the repairs, maybe there's a way to resolve the relationship so that the tenancy can continue. The tenant doesn't end up homeless or having to spend the money to find a different place to live, and the landlord maintains what otherwise had been a good tenant before. So asking the tenant about these things could lead to a good resolution in mediation, and understanding what each party's ideal outcome would be is important in starting the mediation process. Keep in mind that from a tenant perspective, tenants do want to avoid eviction because they do not want an eviction on their record. Having an eviction on the record, on the tenant record, makes it very much harder for a tenant to find housing in the future. And though, as Patrick said, it may be difficult for landlords to collect against some tenants because the tenants don't have sufficient income to be garnishable, or because they don't have property that is not protected from collection, they are concerned about their credit rating, and they are concerned about not having debt following them. So tenants do have an interest in avoiding eviction, because if they can avoid eviction, their lives don't get worse. I think that's probably the best way to put it. Anything else that you'd add, Kim?
Yeah, I think just to piggyback off one thing you said, Denise, which is really important in issues why we had Joan here today, is that the nature of the situation right now is so ever changing. On September 15th, we learned about the Illinois court-based rental assistance program, which will expedite people's applications if they're presently in eviction court. And we're not expecting the mediator to know all the nuances of these rental assistance projects, but we'll keep you informed of while they're out there, because, like Denise said, they might have applied, well, the portal to apply was open in July, or they missed it. They didn't do what they were supposed to do. And now there's new money, there's, something available. Rumor is that more money will come, or more programs will come out next, money for help with utilities that are back due and whatnot. So we just want you to know as a mediator that there is unprecedented assistance that's out there right now. And you might be mediating an agreement that's more so getting the two people to talk and figure out, are you willing to accept this money as a landlord? As a tenant, are you willing to accept money? There are people who do not want services that are available to them. And then our mediation center will be able to also have insight into where the application is in the process. There's a rule for that. So questions you have that come up, just ask us. So I'll move on to the next slide for you.
So some considerations as a mediator in talking to the two parties. There may be a power imbalance between the parties, and some of that could be related to whether the parties have legal representation or have had the ability to talk to an attorney about their specific situation. And this goes for landlords as well as for tenants, because as I said earlier, some landlords are trying to go through this process on their own without the benefit of legal representation. And they may not either know what their legal rights are or know what their understand well what their goals in mediation might be. And this might be the same for tenants. As I said before, not all tenants and landlords are the same, and not all tenants and landlords have the same financial resources and other resources. You've already met Joan Fox. Prairie State Legal Services is going to be available to tenants through the court process, but can also meet with people after mediation. We can meet with people before mediation. You can refer people to us and schedule mediation for another day if you think that that would be helpful. Something to also consider is that the primary interest of the parties might not be what you would expect them to be. It's important to keep an open mind and to hear what the parties are saying their interests are, and to help them reach an agreement, even if it's the agreement that you might not make. You might assume that that somebody who has been unable to pay their rent would be better off moving out and staying with relatives, but they might not have relatives who they feel it's safe to stay with. Or you might assume that they want to stay in the place where they are, but really they would prefer to be someplace else for any number of reasons. People are concerned about where their kids are going to school. People are still concerned about COVID-related issues, doubling up with relatives who are senior citizens. When a party has kids who are too young to be COVID vaccinated, could be a concern. And so there are just a lot of different factors in the mix right now. And it's really important to give people a chance to explain themselves, and ask open-ended questions and really listen to what they're saying, always, of course, keeping in mind that there is very often common ground that the parties have not had a chance to explore. The final point that we wanted to make is that if you mediate cases in other circuits, keep in mind that different courts, different judges, different sheriffs handle these cases at different rates. Stay in contact with the mediation administrators in DuPage County, because we think as the eviction moratorium winds down and the mediation program begins, that the timeline for how quickly evictions move in DuPage County is going to change, and it's going to change probably several times. As more evictions go through the court process, the sheriff might get backed up on how quickly they can enforce evictions. And then as things even out again, probably there'll be an even different timeline. So you can ask the Mediation Center for updates, and having that information will help you lead the parties through the mediation process, because it will give you an idea of how quickly the process will end, and the timeline matters to both landlords and to tenants.
Exactly. these are just an example of common questions you might ask in any mediation. I think we can let you read them. Some of the biggest would be, just to really let them think about, how many hours have you put into this case so far, and to piggyback off what Denise just said, how fast is this case likely to go, and to really help them realize like mediation's an opportunity to reach your own agreement on your own timeline, one that's beneficial to the both of you. No one knows if we are going to have a surge of filings. I mean, we expect it, we're prepared for it, but will it happen? When will it happen? Nobody knows. I don't know if you want to go into any more of these, Denise, or.
No, I just would make the point that eviction is expensive for everybody, and poverty itself is expensive. People, every tenant who's moving has to make applications someplace else, pay the application fee, think about the security deposit, think about the first month's rent, and it's expensive for landlords. Cleaning the apartment, preparing it for a new person, finding a new tenant, going through the process of administration of the new lease is expensive on the landlord end as well. So parties do have an interest on some level in maintaining the relationship if the relationship can be salvaged and is maintainable. So keep, and I think that sometimes the parties lose sight of that because the situation seems to be sort of just embedded in conflict. But if they can, think about their real interest and what is best for themselves, their families, and for the landlords themselves, their families, and from a business perspective, their business. If you can ask questions to kind of draw out those concerns, I think you might be able to find common ground among the parties that would lead to a resolution, either to pay and stay if the tenant is able to pay and stay, or a resolution to end the relationship on terms that are acceptable to both parties. One thing that I wanted to mention, which I think, maybe because of the large debts that we're seeing tenants have now because of the results of the COVID crisis and the eviction moratorium, is that in some cases, there are other programs that provide rental assistance sort of in smaller chunks, which could provide rental assistance for the moving process, for a security deposit, first month's rent someplace else, or for those tenants that really are just behind for a short period of time and can get back on track with their rent, that they get a few $1,000s to cover, last month's rent and the month before, and maybe they're now able, because they're more fully employed, to continue paying rent under the lease as they had previous to their shorter term financial crisis.
Exactly. And that's one of the goals why we want them mediating towards the end of their ability to, hopefully we would have gotten them before they get to court, but if not, they have these resources so that they can come to the table with that knowledge. Do you want to go over any of these, Denise?
No, I think we talked about a lot of these issues. These are sort of questions that mediators, can think about as they're deciding how to begin the conversations with the landlords and tenants.
Right. And, obviously those are not questions you ask every mediation. These are just questions out there to help spur your thoughts and trying to plan ahead on what we're even going to be talking about while we're cross-talking. More questions for tenants and landlords for you to review. Okay, now we're going to focus a little bit about working with self-represented litigants. You may hear that referred to as pro se. I know that all of our participants are coming from in today's training are coming from a wide background. So just some strategies to think about, to use casual language where you can and avoid legalese with everyone, the attorneys included. It helps level the playing field. It helps, a tenant or a landlord might even understand that word, but when they're in the heart of talking about these issues and emotions are high and they're raw, just speaking calmly and in casual language can really help people have buy-in to you as a mediator into the process and allow it to really efficiently move forward. If only one side is represented, you don't want to allow the attorney to take over. You know, keep balance in mind. If the attorney's been talking the entire time, to reel them back. You know, do you want to talk with them separately, separate them into different rooms over Zoom? We'll get into those details in a second. If they ask you for advice or information that you can't give, because that's not your role as the mediator, your role is to be neutral. You can't give them legal advice, even if you know the answer. If you don't know the answer, you're not going to make it up. You know, use that facilitative approach to turn the question back to the parties. You know, even where at the end, perhaps they're like, well, what would you do? You know, it's not up to me to decide. This is your mediation. This is your chance to reach an agreement. It sounds like you've been open to the idea of blank. Bringing that back to them, to reminding them that this, you know, it's on them. Of the emotions that you're seeing from the landlord and the tenant, that gives you a lot of information to figure out which direction this is going to go. If a landlord is, you know, for example, very angry and they're not interested in any of their rental assistance money, and the tenant keeps talking about the rental assistance money, you know, let's pivot. You know, it sounds like that the two of you are just not going to reach an agreement on this issue. Where else can we explore where we could reach an agreement? You don't want to talk to one party without the other one unless the parties know that that's your intention. So for example, you just don't want one litigant to think that you've favored the other side, that you're being socially, you know, social or friendly without them. You know, even this casual kind of references where you're typing up the agreement and someone says, yeah, the other day when we blah, 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 because perhaps you've mediated with that attorney and that landlord before. It leaves a bad feeling in people's mouths that this wasn't neutral, that this wasn't a level playing field. And so to be really aware of that, and to clarify if someone says something that implies you've had a conversation privately or that you're not neutral, that you don't assume that people get that you're upfront about it, and explain that conversation. You know, for example, you know, someone says, well, before you joined, blah, blah, blah. And you say, I was on mute. We were not participating in that conversation, that the mediation hadn't begun. I was not listening. My camera and my volume was down, something like that. Speaking
Kim,
of,
there's a question.
Yeah.
The question is, what is the best way to handle a party that does not want to be in mediation?
Well, first of all, you can't force someone to mediate. You know, I think a common way to approach it is to say to them, you know, I understand that this isn't where you want to be. You know, you are ordered to be here today, but it is, you know, it is already your time. So let's make the best of it and let's see where you can get an agreement. And if you can't, I at least want you to leave here with a better understanding of where the other side is coming from. Because even if mediation can't resolve your dispute, this process can keep your dispute, can resolve your dispute quicker or more efficiently. And you're here and you might as well use it. And if they just won't participate, you know, you end it as the mediator. And, you know, you can also remind them, you know, the judge ordered you to mediate today. They didn't order you to agree, but they ordered you to participate in mediation. And, you know, I ask that you give that participation to this point. And you can choose to maybe put them in a breakout room to say that to them privately so that the other side doesn't think like, haha, you know, that mediator's on my side. Because I promise you, no matter how many times you remind people that you're their neutral and that your goal is to get them into an agreement, it's this like innate, like, I'm going to win, you know, I'm going to get them on my side as if you were their judge and you're not. That's a great question. Thanks, Denise.
There's another question that's related. How much time is allowed for mediation, which I think you're going to get to soon? And will there be an order compelling the parties to participate in good faith?
Yes, to both questions, and we'll explain them here in a second. Just a tip, as all of our mediations will be occurring over Zoom, at the beginning we have space available for in-person mediations once allowed. We're under social distancing and mask guidelines by the Illinois Supreme Court. So for now, we'll be mediating exclusively over Zoom, and I'll give you those details, but we want you to log in 10 minutes before to make sure that your technology is working. We will make you the host of the mediation and give you a phone number to be able to call us if you have any technical issues. We don't want to let anyone into the Zoom mediation who's not a party to the case. Just like with in-person mediations, these are confidential. Only the parties and their attorneys should be there unless all parties are agreeing that so-and-so can join. So you want to make sure that that's understood by everybody and not presumed. There are just a lot of things that you might not have to say if you were in person that you're going to want to say in a Zoom mediation. If they're in the waiting room and you're waiting for the other party, send them a message that, we're getting started. Our mediation center will get things started for you as well. Engage with the parties when they enter, but professionally and neutrally, to make everyone not feel like they missed out on a part of a conversation. I think mediation is great over Zoom. One thing you just miss out is like physically understanding who was there first and that kind of dynamic. And so you just want to explain it for everybody. Things you want to consider with self-represented litigants especially, but with everybody, to be aware of your own biases and assumptions. You might be looking at a tenant or a landlord and they're saying they don't have a dime to negotiate this. I'm already this much behind on my own mortgage because of the tenant, or I can't afford anything because of X, Y, or Z when they're the tenant. And you find yourself thinking, well, you're dressed pretty nicely, or that watch is this, that, or whatever. Those are biases and they come through and you really need to check them. You don't know anything about this party, even if you've mediated maybe that landlord in a different situation. This exact case is different. And when you find yourself getting into like a cookie cutter way of handling every case, your participants feel that and it really discredits you as a mediator. Again, don't presume that you know something, ask it, especially if you feel the other side isn't understanding that. Ask it so that the parties can be on a level playing field and both understand it. Consider your privilege as a mediator. This for us is not our losing our housing. It's not us not getting the rent for our income. And we're in a different spot than the landlord and the tenant are, and the attorney participating in this mediation if they choose to do so. You may have access, knowledge, and means that the parties do not, just even this training that you've had, our participants will not. If their mediation is happening with an interpreter, again, if you do speak two languages in your application for mediation, there's an opportunity for you to put that if you feel comfortable mediating in that language, but our court will provide interpreters, and there is a dynamic that goes along with that to make sure that you as a mediator are allowing everyone to have that access to language. The comfort with technology. You might say, I'm going to put you into a breakout room so I can talk with you and caucus with you. Like, they may not understand what you mean by breakout room or caucus, to again use plain language. I want to take for example, I want to take an opportunity to speak with you privately. I'm going to move you and I into our own separate Zoom room so that you and I can communicate. And then I'm going to do the same thing with the other party. And even to go so far as to say, I'm going to try to spend equal amount of time with both of you, and then we'll come back together. And then if something happens that you're not spending an equal amount of time, address it. Don't just presume, again, that people would understand. Example, tenant or landlord's microphone went out during this time. We had to spend some time getting back together, whatever that time disbalance might have been. And then remember that the clients reach the agreement. It's not the mediator who tells you that you're in agreement to something. If someone is hesitant, you clarify with them that they understand. Are you sure you're in agreement with this? And not just to let their silence imply that they're in agreement. They need to vocalize that they agree.
Can I add one thing, Kim? Also, keep in mind that for low-income tenants, and also this is true for some landlords, technology is a real problem. And this is all going to be happening by Zoom, and Kim's project has made space available in the courthouse for people who need to come to the courthouse to use the computers there for Zoom. But people who are low income, who are struggling to pay their rent, may not have access to a decent computer in their house, may not have access to decent headphones. They may be using a smartphone that's not the best quality smartphone to access the Zoom. So be patient with people if their connection is going in and out. Sometimes that can be seen as disrespectful. But a lot of people do not have a lot of control over the quality of their internet service or their data service.
Good point. So our program, at least initially, is hoping that in a 3-hour shift that a mediator could serve, they could get done 2 to 4 mediations. Once we see in reality how long they're actually taking, we'll update mediators, but we would hope that you could get most mediations done in 30 to 60 minutes. Kane County is currently doing eviction mediations, Cook County is, and this is what we've heard from them about where they're at. Again, then no one's had the volume yet that we're all suspecting we'll get once the moratorium is over. In your packet, I provided you with an example of how much time you could spend on each session. Most people lose attention after 15 minutes, as you might be feeling in coming to our 4-hour presentation today. So it's really important that your opening statement is prepared ahead of time and it's ready to go. I gave you an example of an opening statement on page 88 of your handouts, and it contains the things that we would like you to say in your opening. Of course, you can make it your own, but it's really important that from the get-go, everyone understands that it's voluntary to reach an agreement. Everyone's ordered to come and to participate, but they don't have to reach an agreement, that this is confidential, that everything that's said in here needs to remain in here. No one's to record this or allow anyone else off camera listening. That you are there neutral, that you were given training to participate in this program. You were provided to them free of charge from the court assigned you, and that what you're going to do, like a timeline. We're going to identify the issues and the reasons that you're here. I'm not able to give you legal advice. I'm not going to recommend a specific outcome. And everything that happens in here today, if we reach an agreement, I'm going to type it up and share it with you so that you can read it. If you don't reach an agreement, that's completely fine. All the court will find out from me as a mediator, yes, you agreed, or no, you didn't. Then you move on to, issue spotting, setting the ground rules. Key to these mediations, because we do need them to move along, and there are not, usually tons of issues, is to be upfront about the time. We're on a limited time crunch here today. Not time crunch, it's anxious, but we only have a certain period of time today. And my role is to make sure that we're communicating effectively and efficiently. So I'm going to remind us as we move along that it's time for us to move forward and see, if we can move on to the next topic and see if we can reach an agreement with it. So a 60-minute model would just allow you to have more time to issue spot and to crosstalk, and a little bit more time on the back end to write up the agreement. So I've given you some tips in here on what you want to do in your opening statement, and went over that with you already. It's important to set ground rules from the beginning. We're not going to be interrupting each other. Using language that's respectfuful about that. Before you go any further, let me make sure that I understand you and summarize their point. Or if someone's going off on a tangent, this isn't the same kind of conversation we have with our friends or in a back and forth conversation. This is concise, structured communication, and really summarizing, reminding them of the time, but not overly to the point where you feel like, their heart is rushing. An idea of how to handle interruptions. There are some you just ignore because it's going to take you more time to address it than to talk about it. Giving them some nonverbal cues, like normalize that, that interruptions happen, thank you, acknowledge your emotions. I can see and I can hear that you're really upset about this right now. can we circle back to, blank that we were talking about? You need to increase your interruption while, reminding the ground rules. Perhaps, we agreed at the beginning that no one was going to interrupt the other party. I want to remind you that we have 30 or 60 minutes with each other today, and it's already, 40 minutes in. We really need to get focused on to whether or not you can reach agreements that we've talked about or proposed so far today. And then finally, moving them into separate rooms so that you can caucus with them and just directly, talk to the party without the other side there. You can be more blunt and to the point when they're not in front of each other talking to you. In that crosstalk or joint session, it's really important that you focus on balance. Don't get into a pattern of interviewing each other. Number one, that takes a lot of time, and it becomes a game of ping pong, and it gets us away from agreements. To explore the options as they come up. What benefit does this offer provide? Is there room to go further on this? Is someone completely shut it down? And then, tips for Zoom. Again, if someone misses something because they couldn't hear, tell them what was said, assure them that they didn't miss out. If someone can't be heard, pause the conversation and don't talk. Let that person reconnect. Besides, technical issues. And again, like Denise said, we have Zoom capabilities available in the courthouse and in the mediation center in the courthouse to give everyone access to competent internet and technology. I've gone over some communication strategies in here for you, how to ask, focus, open-ended question. Instead of asking someone, what did you think of your agreement? What were your expectations about the number of tenants residing in the unit? Not to open the door to all of Pandora's box of problems, but exactly this is the issue and how do we talk about it, but in an open-ended way. And to lead with empathy. These situations are really hard, and especially when, you are trying to do them in a certain amount of time. If you just steamroll over it, you might lose that person completely, and you just don't want to be the reason why the mediation didn't reach an agreement. And again, as we all do this for the first time, we're going to see how long they take, and we're going to see what's going on, and we'll figure it out. We're going to have mediator evaluations available for you. We'd love to get your feedback on the program so that we can make changes where we need. Finally, with some reality testing that's going on, if you want to mediate efficiently, it's better to do it with them in the same space. It happens quicker than going back and forth. And so to do that in the same spot, whereas you can reality test someone with pretty blunt or clear language when they're private, doing that with the other person there is really asking those facilitative questions, those pointed thoughts. Sorry, I'm almost out of time, so I'm trying to get to points that we haven't already addressed today. And you can reality test even when the parties are represented by attorneys, not to let the attorneys, they're there to be that party's zealous advocate. That's their role. And they may know exactly what they want because this is what they want to get for their tenant. But, to reality test with them there too. And again, not to shy away from putting people into separate rooms and going back and forth with them. You could do that too. And when you are shuttling or caucusing between the two spaces, you really want to have that balance and transparency that's there to maintain your neutrality. If you find yourself with one party longer than the other, give an explanation as to why that happened. And then we're going to move on after this section. We're going to get into it with Ron and David, who are going to help us figure out just kind of the types of agreements you're going to get out of these mediations and how you would memorialize them into various court orders into a generic memorandum of agreement. But, how do you know there's no agreement? You've tried everything. You've tried again, perhaps issues were brought up earlier on that someone shut down, but something's happened along the course of our conversation that makes you think, hey, they might be open to that, readdressing it. if it's just not there, we're not there to like, hey, I have 60 minutes and I'm going to beat you down and you're going to get this agreement. If it's clear very early on that there's just no agreement, it is what it is. And you wrap that up and you make sure that everyone at least heard their point, because mediation is still considered a success if perhaps the mediation doesn't result in agreement, but afterwards, the parties at least had an opportunity to, pause. We're not in court, to think to ourselves, you know what, I didn't like it at the time, but this, the tenant, the landlord mentioned this in the mediation, I can agree to it. Or my tenant, I didn't have an attorney at the time, or my attorney wasn't with me in mediation, but the tenant or the landlord said they would possibly do this. I've talked it over with an attorney and I'm in agreement to it. And they enter an agreement before their next court date in the case, or the case doesn't end up proceeding to trial. In the terms of alternative dispute resolution, that is a win. Anything that isn't adjudicated by the court and is left off to the parties to reach an agreement is there. And to consider those, ethical considerations. We're not forcing people into an agreement. We're not having them agree to something that feels unconscionable, because that's not our role. So I'm going to stop sharing my screen at this point. And I'm sure I see a bunch of questions I'm going to try to answer well. We welcome Ron and David back to go over using court orders. And I'll finish off with you too. So if there are questions in here I can't answer in the Q&A, I will answer in the last section today. Thank you, Denise, for presenting with me, and I'll turn it over to David and Ron.
Thank you so much, Kim, for putting this all together for us.
And David and Ron, you can see the PowerPoint, is that correct?
Yes.
Yeah, absolutely.
Okay, and just give me a clue when you want me to click on a form, and if you need me to scroll down the form.
That would be great. What's the, can you click to the first form? That would be great.
You know,
Kim, oh, go ahead, Ron.
well, what I would like to do is I would like to look at the Supreme Court, how to use different types of orders in eviction cases, and the second page, eviction court, how to use different court orders. I think that handout is really an excellent handout, and what it does is it shows the difference between agreement, no agreement, voluntary dismissal. And the issue for me is there's three of those orders are for agreed settlement orders or agreed dismissal orders, which is essentially the same thing, an agreed settlement.
Can you hang on 1 second, please, Kim? We're seeing your screen.
Yeah, this is the document.
Is that what you want? Okay.
Yeah,
That's it exactly.
Is that the one, Ron? There's also a summary sheet.
Yeah, this I think is an excellent document to refer to when the mediators are trying to come to some kind of an agreement or trying to write up an order. And what they need to keep in mind is that these orders, the settlement of the case, it's really about time and money. And what the court is going to want is a disposition of the case. So with the first agreement, the agreed dismissal order, case may be reinstated. I think that's an excellent way to resolve this. In that agreement, the parties agree about lease violations or other issues. Plaintiff agrees to dismiss the case, but has the right to bring it back to court if the defendants do not follow the agreement. No future court dates. The plaintiff has to file a motion to reinstate. Now, I think you can be pretty creative with the kind of agreement that you get that dismisses a case. You can ask for maybe a little bit longer payment arrangement. You can do things that you may not be able to do in the other types of agreements. and if the defendant doesn't comply, then you can reinstate the case, file a motion, reinstate. The second agreement, well, the other two agreements are, and I would prefer, in terms of prioritizing the kinds of agreements that tenants would prefer, I think that a pay and stay agreement is better than a defendants will move out agreement. I mean, and from the perspective that what that means is the defendant gets to stay in the residence. Now I'm assuming that they're going to have to come up with money, and that's where the rental assistance agencies come in. But a pay and stay agreement preserves the status quo. The tenant gets to stay there, lease is reinstated, landlord gets paid, and everything is good. If the other agreed settlement order, the defendants will move out, that may be, I think, to me, that's more of an order that would be appropriate or more palatable, I guess, in a situation where there is a 10-day and the landlord would rather get possession and put the money order, the money claim off. They just want the tenant out and non-suit the money. So that may be a more suitable agreement in that kind of a situation, a 10-day situation. What's your perspective on those, David?
I think that's a really good approach. I mean, our concerns would be, so these are all the Supreme Court eviction form orders, with the exception of, there's one which is a memorandum of agreement, which is a DuPage form. So, you can have an agreement, possession, money to be paid, possession to be surrendered or not surrendered, with the dismissal with the leave to reinstate. The only issue I see with that is that if there's a default on that agreement, we have to file a motion alleging the default and come back into court. That's a lot of extra work. And from a landlord's perspective, we might be willing to do that depending on the case it is, and also how comfortable we were that the tenant during the mediation, that we felt comfortable that they were going to comply. But I would hate to dismiss it and then have to go through the efforts, more expensive for our clients. It's, potentially more expensive for defendants as well if we have to file a motion again to enforce compliance with the terms of the agreement. So as Ron said, I mean, that is an option to set out the agreement. If it's 10-day, you could just do a possession order, dismiss it. If they don't move out as agreed, you can come back in saying they failed to move out. I also noticed there's some other language in the lease that you have to continue to comply with the terms of your lease agreement. If there's money due, sometimes it's a bit complicated to figure out exactly what's owed. For example, in a multifamily property, utilities are typically billed in arrears and they vary from month to month. So as a landlord's attorney, you may want to add some room in the additional provisions saying whatever's due will be plus whatever the utilities are for those particular months. So you'd have to be very precise in the amounts. As to the other two, where there's a compliance date, one's an agreement to move where the tenant's going to move out and pay a certain amount of money. If they don't, the order gets entered. And the other one is a pay and stay. And I think what Ron is saying is, the timing of that will be critical depending on what type of financial resources are available through the county or through the state. And there's two of those. There's two that get continued for compliance with a compliance order as well, which sets the date for review in the court. So it ends up on the court calls. And then there's also just a straight eviction order. I'm not sure that would be super useful, because I guess the whole point of the mediation is to come to something other than just a judgment and a move out date, a possession date, but that's still an available form. And then if you wanted to craft something more specific to the situation, or something that doesn't fall easily into these other forms, you could use the memorandum of agreement, which will be available, I think, right, Kim, through DuPage.
Yeah.
And that will be something that you might, the Supreme Court forms there's a lot of boxes to check, and there's not a lot of room for creative orders or things that might not fit kind of a certain pattern. So you might end up using the memorandum of agreement just to easily set forth some different agreement that doesn't fit easily into the form orders from the Illinois Supreme Court. I think the charts are really helpful as well. So I think it's a really helpful reference. Go ahead, Ron.
Actually, I was just going to agree with you, David. I think that what's really critical for these forms is that you don't that the ultimate agreement doesn't lock the tenant into failure, and the agreements have to be realistic. So the orders have to provide for a realistic time frame for them to come up with the money. A time frame of, say, $1,000 a week for 26 weeks, is that realistic? I mean, it could be realistic, I suppose, if the tenant is now gainfully employed at a good paying job, but I think that whatever agreement is used, it has to be realistic. It has to reflect reality. It has to reflect, a realistic view of how much rent assistance this person is going to be eligible for, what they're actually going to get, when they're going to get it. I think that this is how the case is going to be disposed of, and it should be disposed of in a way that all the parties are in agreement, and it has to be a realistic agreement. So that's kind of what I wanted to
Yeah, I completely agree with that. And I think we talked about that earlier in our presentation, that one of the factors that we would look at is whether or not it's reasonable, like any sort of an agreement. What are the resources that are likely to be available to bring the account, whatever payment plan is agreed to, and how likely is it going to be able to get into play? How quickly will it get into place? So there's no reason to enter in an agreement that everybody knows is not going to work and just be back at square one. So it's got to reflect what the parties think is a possibility of success, and that's something that just sets people, as you said, Ron, sets people up for failure.
Yes. And the two things really that are in play here are time and money. Can the landlord provide some additional time for this to work out? Can the tenant come up with more money? Are there other sources of income or revenue that they can tap into? What kinds of things can we look at here? And and we talked about you mentioned earlier what the landlord looks at, and if we're talking about somebody who's been in this apartment for 10 years, that's different than somebody who moved in 3 months ago. So I think that those are the kinds of considerations that may add, I guess, an element of credibility to what the tenant is trying to come up with. So I think that those are also factors that should be taken into account when these orders are being crafted.
Yeah. I mean, I think something could be added to an order if part of the plan is to apply for assistance, rental assistance, about some affirmative duty to complete the application or to take whatever steps are necessary to move forward with that. And I think, you know, Kim, I think, would that be appropriate in an order?
Yeah, I was actually just answering Naomi's question on the chat about that. Piggybacks that she says if the tenant is depending on financial assistance, how would the agreement be written? I think you could do two things. You would do what David just said. The tenant is expecting an answer on this around this time. Now, remind you, we just learned as of last week that we will be able to call anyone participating in the Illinois rental assistance project to find out where they're at in the process. Now, we may not know that right away if they're going to pick up our phone when we call. So that's why Joan side and our mediation center are going to be able to communicate in advance so we can enter the mediation so people know this information. But back to that, you could, if this, then that, if the tenant receives this money by this date, this is going to happen. Or, I don't know if there's going to be a lot of buy-in to this idea, but if both parties are wanting this money and are agreement and want to mediate again, they can agree to a future mediation date. And we can schedule them a mediation and report to court that both parties were mediated on this date. They've agreed to mediate again on blank date, and then get a status date after that next mediation, and allow them to come back to mediate when they have that answer.
Yeah,
It'd be nice, I think, to have this. This is in your packet on page 108, this memorandum of agreement, a more blank order. This is what we've agreed to for those unique situations. And we don't really know how there's $60 million available to Illinois for people, the Illinois court-based rental assistance program. We don't know if they say that they'll be able to process those applications within 2 to 3 weeks. If that's true, then people will mediate after that process. If it's not accurate, this will be a different situation, and we'll modify it, and we'll be keeping everybody up to date. We'll talk about this in the next session, but you'll get an answer, information from the mediation center like 48 hours before your mediation, giving you what you need to know to be able to mediate that case. If there's those unique situations. There might be a lot of people who've already applied and been denied already, and they're coming through to mediation. Or, if people reach an agreement on their own because of this money and don't need to mediate, the mediation order provides that parties can call us and tell us they don't need to agree and enter an agreement in their agreement in court. And that's a win for mediation too, because there was this mediation date that was out there that got the parties started, the program got them connected to resources, and agreements were reached. Did I answer that?
Yeah, that's great. I saw that Ted Donner asked a question about making sure the agreement's realistic, and at what point do you kind of assess that? Or do you create an agreement and then check with everybody to make sure it's realistic? I think really that happens much earlier in the mediation process, because I think some of the questions might be, can we, do you have to go through some specifics about what the plan is in terms of getting an account up to date if it's a non-payment case. So it would certainly be something you wouldn't wait until the end to see if it's realistic. You would be having the parties engage in that conversation early to see what's doable, and not just saying, well, gee, can you pay $20,000 30 days from today? And yes, you agree, we write something up. There'd be much more of a discussion earlier in the mediation about how that might happen, wonder if it doesn't come in on time, who's going to do what to make that happen. And then I think at the point you're putting an agreement together, you're memorializing what the parties agree is a realistic solution.
Yeah, especially because, you know, you're trying to do this quickly, not quickly offensively. And, you know, our goal is to get 2 to 4 mediations done in a 3-hour period. That seems on par with what people who are meeting these cases have already been doing. I think there are some people who may hear me say that and say, what? Like, we can't do that much faster. You know, every situation is unique, but you know, if you really want them to get an agreement, if you wait to reality test till it's too long, it's going to take a longer than I think ideal. Also, too, like, remember, this is if someone's attorney is applying or they're off of work, they're on their lunch break or whatever, you know, they might also not want to be in it forever too. And they might just be like, I'm not agreeing to anything, tick, 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 you know, this is frustrating. Okay, anything else in this section? And then,
Well, you know, one other point that I would make is that the parties have to show up with authority. So they do have to be able to make decisions as to what the agreement would contain. So I think I think that needs to just be made explicit, that if the party doesn't have authority to settle the case, they really shouldn't be there.
right. And the local court rules provide for that too. Those are at the at page 124 of your packet. They begin, and they're also on our website. Anything else? Okay. I'm going to get through these questions and ask my fellow co-panelists to answer them if I can't. I'm now going to start the next session, which, yeah. Someone going to say something? Okay. We are going to start with going over these program logistics. I think we'll put a nice little bow on this package that's been presented with you today. You've made it to the end. These are the logistics of our program so far. So to give you all kind of, again, that foundation to why we have this, you know, the program has been designed to help mitigate the surge of eviction filings resulting from the COVID-19 pandemic and the ensuing economic fallout. Our goal is to assist both tenants and landlords in avoiding eviction and pursuing mutually beneficial alternatives. This program is to avoid exposing DuPage County families to homelessness during a serious health crisis, while also helping landlords to mitigate their losses during such extraordinary circumstances. Our program is also designed to aid in the administration of justice by promotion of judicial efficiency. We have local court rules that were developed and approved by our circuit court judges and Chief Judge Popejoy, and they are included in your packet. To apply as a mediator, one of the questions we're going to ask you is, did you read these rules? And so you want to answer that question, yes, when you apply, and give them a peruse. They're on, again, 124 of your handouts from today. If you also misplace your handouts or need to find them, you can get them from our court's website, right? dupageco.org/court. You can click right at the top of Residential Eviction Mediation Program and Resources, and that'll take you to everything you need for today, along with the application to apply. So these rules set out the rules for the program, its existence, and also provided that in all mediation cases starting September 20th, that tenants and landlords need to provide we'll get service notice of the mediation program. I included for you on page 133 of your handouts a copy of that handout. Again, it's another way to connect tenants and landlords before they come to court with referrals to community services, to legal services. And as of now, we're going to be mediating cases that have a filed eviction. So if someone were to call us in advance of their return date, for example, and want to mediate, the rules provide that we will reach out to the other side to try to schedule mediation more timely. Otherwise, everyone will get ordered to mediation based on the judge's discretion at their first return date, or whenever the judge has jurisdiction and both tenants are there. So For example, if both tenant and landlord are there on the return date, the judges could order mediation. If they show up at the bench trial, they could, for the first time, the judge could order mediation on the spot right then. The judges have, per our local court rules, 28 days to schedule the mediation. The mediation appointments will be ordered by the judge. Again, just with the volume we're expecting, this is going to be the best way to get individuals connected with the mediator. Typically, again, at the judge's discretion, the mediation is going to be scheduled towards the end of the 28-day period. This is going to give opportunities to the parties to get legal advice from their attorneys, or seek that out if they're interested, and connect with community services on rental assistance. If the judge is hearing something from the parties that makes them think they don't, they're going to schedule mediation differently, they can, and we'll have mediators available for them to do that. Like I've mentioned already, we're hoping to have mediators serve a 3-hour time shift to do 2 to 4 mediations in that time, Monday through Thursday mornings, 8:45 to 11:45. We may change the times of these shifts to the afternoon or days of the week, depending on the kind of flow that we see coming through. To access your link to mediate, it's really easy. You would click on the 18thjudicial.org website. You click on remote court proceedings, and it'll take you to the clerk's website, where you just enter the case number here on the box on the right, and you hit search schedule. So our office is going to provide you with the case number you're mediating in advance, so you know which case to put on here. Because these cases are impounded, as of now, it's understanding that the only way to find them is to actually put the case number in on the website. If you'd practice in DuPage, or you've attended Zoom proceedings in DuPage County, traditionally you can search here through a courtroom number. We're going to be room 344. That's not how you would find these cases. So if you are not interested in serving as a mediator over Zoom at this time, that's completely fine. Please still apply and let us know that you're available for in-person mediations when we do that. Our office you're going to join the Zoom link through the website, and then our mediation center will be the host, and we'll bring you in, connect with you while the parties wait in the Zoom waiting room. We'll make sure that if you have any questions, that we answer them for you, that your technology is working. And then from there, we'll make you the host so that you can bring individuals in from the waiting room, be able to move them into breakout rooms, and end the session when it's over. Remember, since you're the host, that these mediations are private and confidential. So if you see people in the waiting room who are not allowed in, you don't let them in. Our mediation center staff will have our video off and the volume off. So you will call us if you have an issue. You can always bring someone in from the waiting room to see who they are first, all privately, if our office hasn't done that for you. If you reach an agreement, you need to be able to share your screen over Zoom, and so have that skill set, and to be able to show them the agreement that you've typed up. And then we're allowed to use electronic signatures, which means that on the lines that signatures would go, you would just use that /S/ to get their agreement or their signature. And then if you are not so sure about your Zoom skills, we will have a Zoom guide put together that you could reach out to before, but we will ask you in the application to be honest if that's not something that you're skilled at right now, because you will be, in charge of running the mediation sessions and need that ability. The DCBA is in the works of putting together a Zoom tutorial for anyone interested in taking that. You can reach out to me or a mediation center for that information if you can't find it on your own. We have a mediation center, which is located at the top floor, the top of the 3rd floor escalators to your left. We have 4 mediation rooms as well as a waiting room. Our program coordinator, Alyssa Fortino, will staff the center. She'll start the mediations, when they are in person, and then now as they'll be on Zoom. And she's going to be an on-the-spot help desk and referral to services for people in the courthouse who, we're going to have someone there to be able to answer questions that anyone can send them to. And then our mediation rooms have Zoom capabilities, again, to give people access to the technology and the internet they would need to participate. And then when mediations are in person, the ability to use the laptops to type up the agreements that you reach in your session. This is just this idea of what the to-dos are as a mediator, so you know what we're asking and thinking of applying. So basically, to sign up for your availability, we are putting together a really simple tool to be able to sign up for dates and times that work best for your schedule. And then we will give you as much notice as we have if we don't have any mediations for you. That means the money is getting where it needs to be, and we're not as surging as we thought. We'll let you know that your time is canceled, because we know your time is very valuable. But sign up for as many shifts as you want to be able to participate in the program. And then when you are accepted, you'll receive a manual from us that gives you all of this information that we've gone over today, and to be able to help you do your case, cheat sheets for you, sample opening statement, etc. You'll be logging into the Zoom mediation, so you'll need to know how to use Zoom effectively. You'll go over your opening statement and a confidentiality agreement, which that was one of the questions in the Q&A. And we have that available for you as a sample on page 134 of the handouts for today. We'll give that to the mediators the day of too. It's written in plain language. It outlines for everybody the role of the mediator and the confidentiality of the process. Everyone will electronically sign it, and then our office will file it for everyone in the court case so that it's there. Then you'll do your mediation. When you're done, you'll share, if you reached an agreement, you'll share your screen over Zoom, make sure that everyone's read their agreement, they've verbalized that they agree to it. You could read it out loud to the parties, just to make sure that everyone, is able to read and understand what they've agreed to, and that they verbalize that they are. If again, you can choose to ask people questions. It's better to ask that they understand than to presume that they do. Mediated agreements are not binding. So if someone does not, the agreement falls to court before it is entered in court, that's simply what the judge finds out. And then you conclude your mediation. You thank the parties and the attorneys for their time, and that they'll receive the agreement and the court mediation report from the mediation center. And then you send an email to us with the agreement you typed up, and just in the body of the email, a quick, they agreed, they didn't agree, or they reached an agreement to mediate again, and we're mediating on this date. You probably would have needed to talk to us to get that date, and then the amount of time you spent mediating. This is the link to the application. So it's in your handouts on this application screen. I'm also going to put this in the chat as soon as I'm done with this portion of the presentation. When you click on it, it'll take you to a online application to fill out your information, and then you do have to email us your resume that examples mediation experience or applicable experience to eviction or landlord tenant law, these types of things. Our office is going to start to review applications on Monday and get acceptance letters out to people and give you the link to sign up. We'll have mediation shifts available for starting at the middle to end of October, November, and December. Starting October 4th, that's our kickoff date. Our judges in the eviction courtrooms will have the mediation orders, and we'll start ordering cases to mediation. And then at least a week before you mediate your first case, you'll get our welcome kit from us that includes everything that's in these handouts today, and something to help you read and make sure if you have any questions, you just reach us to us and let us know. We are going to be taking evaluations of the program. So we're going to have links sent to people from the Mediation Center. If you want to give your feedback as a mediator, the tenants, the landlords, and attorneys will be given a separate evaluation to fill out regarding their experience in mediation. Again, to just let us constantly improve this program and let it be something that is the best it can be and a resource to our circuit and our community. We will be keeping statistics on the mediation, basic statistics that we'll report to our administrative office of the Illinois courts. This is nothing that the mediator needs to do. Our office will do it. The information remains private. It's only shared with them, and you'll see that in our local court rules as well. So before we end this, I do want to take a moment to thank, and I'm going to get to all the Q&A, and we have some time here to answer questions that you might still be writing out, but I do want to thank all of you for participating in this. I know this is a huge chunk of your time, and it's wonderful to have you interested in helping this program and the landlords and tenants in DuPage County. If you are wanting CLE for this program, make sure you complete your evaluation soon so that you can get that. And I want to provide you with the Eviction Mediation Center's email and phone number. So this is in your packet. You can get it from there as well. I'll put it in the chat, and you can reach out this way if you have questions. And before I get to the Q&A, I just want to make sure I have it. Well, I have you all just to thank all of our presenters today and last time and our supporters to this program. A special thank you to Chief Judge Kenneth Popejoy and Presiding Judge of Chancery Paul Fullerton, our eviction judges, Judge McCluskey and Judge Belford, Suzanne Armstrong, our court administrator, our presenters from last week, the retired Honorable Ronald Suter and Michael Gelman, an alum of Second City. And then we've, for the past 18 months, been working with a committee of local attorneys, giving us insight to this program: Amy Olson, David Barheit, Ron Soika, Denise Bezic, Patrick Edgerton, Ted Donner, and David Clark. A big thank you to the DuPage County Bar Association for giving us this forum, advertising this program for us, especially Robert Rupp and Barb Mandrella, and especially thanks to Mary Keating and Joan Fox from DuPage County Community Services for their important role in this process. So there are 18 questions in the Q&A, and so we can make our way through those. Let's see. And if any of, let's see. If you have a tenant that has not applied for rental assistance, but is willing to do so at mediation, the landlord agrees. How would you as the mediator draft the mediation settlement agreement? A, which will ensure that the tenant will actually apply for the funds. I think we answered this question already in the two different ways that you could go about approaching that. If you felt you didn't answer that, ask again. Hopefully we can get the copy of the Q&A for you all. These are wonderful questions. If I can't get them sent out to all of you when you apply and become a mediator, I will get a report of these questions for sure and make sure I put together a frequently asked question part for you all to have. The confidentiality agreement, like I mentioned, is the last page of your lengthy handouts for today, page 134. If you could look into that, and we're not going to give it to the parties ahead of time, but I think that's the question, but you will offer it to them right after your opening statement and go over it with them. So Steve Lindbergh's asking, so there is a draft agreement order, how will it be entered and how will the parties be notified of the entry? So I think I answered that in the logistics just now, but the mediator will type up the agreement and get it to the mediation center. The mediation center will email it to the attorneys or self-represented litigants, and it's up to the attorney and the self-represented litigant to get their agreement entered in court on their mediation status date. The attorney could choose to rewrite the agreement on their own if they wish, or use the memorandum of agreement or draft order that you received from the mediation center. And the parties need to go to court to enter that agreement unless, that's kind of procedurally done differently. That's probably what could happen, is that plaintiff's attorney agrees to bring it in. Someone asked I needed in King County interpreters are available. Same here. Courts have to provide interpretation services, language access. Someone asked, thanks for, okay. Can we provide, I don't know what web address you were needing. In the chat, I'll provide the court's website. I'll provide the link to the application. All of those things are in your materials today. Someone asked if the mediation process will be used for commercial cases. No, this is a residential eviction mediation program at this time. Someone asked, will the mediation process, will mediators have to always be available Monday through Thursdays? No, you sign up on the day of the week and the time and the shift that works for you. And we will get mediation scheduled in those times. And if we, for some reason, don't have any mediations for you, we'll let you know in advance so you can make yourself if you are going to cancel, though, we ask that you give us as much notice as possible. And also in your application, if you're willing to serve kind of on a last minute basis, like we could give you a call and give you a Zoom, ask you to log on, we would really appreciate you letting us know that, so that we have a short list of folks that could help out kind of in an emergency. The parties, will we be able to record the parties' confirmation of agreement in the mediation? At this time, that's not the plan to record any portion of this. If the parties no longer agree at their court date, that's what they report to court. The judge will have gotten a report that says, yes, they reached an agreement, but the, on the ends, they get to court, that agreement fell apart, and the case will proceed. Someone asked if there's a verbal agreement recorded in a case and a party later denies the agreement. Again, agreements are confidential. They're not orders until they're entered in court. And that's kind of the nature of mediation. Someone asked, how do you provide translators if it's over Zoom? Will one be available to participate by Zoom link? Yes, we have mediators. We have interpreters serving over Zoom all the time in the courthouse, and they're seasoned at doing that. And Zoom's actually a great function for that as well. Someone asked if there'll be compensation. I actually don't have the answer for you for that at this time, and I'm sorry that I don't. We're in the process of finding out if we'll get the money we've requested to be able to pay mediators a nominal fee for their time that you've spent for this really important cause. If that is inhibiting or prohibiting you from applying to serve as a mediator, I understand. You can email me and let me know if you want to be told later on, or still apply and just simply don't sign up for any slots until we do have that funding. And then I'm going to be putting the link for the application in the chat. So someone asked if there's future court dates on the mediation. Yes, so there's a mediation order. The mediation order sets the case for a mediation date, a status on the mediation, and then there's language in the order that talks about if the parties reach an agreement ahead of time, they can enter that agreement and the mediation is stricken. And that order will be available. It'll be in your welcome packet as well as a sample. But there will be a status on how the mediation went, and our office will provide the court with that report so that the judge will know, did the people show up to mediation? Did they agree the outcome? Someone just asked, so at the end of the mediation, will the mediator send to the mediation center all of the following: a memorandum of agreement, an agreed order, a confidentiality agreement, anything else? Our office is going to provide you with a very helpful, succinct checklist. But you will just have to send the agreement, whether it's a memorandum of agreement or you used one of the orders, the confidentiality agreement, and then in the body of the email, the outcome, and we'll fill the report out for you and how long it took, if you remember. Otherwise, we will take care of all that guessing for you. If there's any other questions, I believe I got through all of them. I just didn't have an opportunity to click them off here. Feel free to answer them. We have about 5 minutes left. I don't know if our earlier presenters, if anyone had questions for them. I know these are all pretty much pointed at me and the program right now. Feel free to put those in the chat. And if our presenters could turn their screens back on, just as I can say thank you to all of you. This really was such an incredible program. It was all thanks to you all and to everyone who supported us. So thank you so much. And thank you. I can't believe we had at one point 127 people really interested in learning about this program. If you're not participating, please let mediators know who might be and to apply. And then I'm going to spend a second here putting the link in the chat for you all, but thank you so much. If you want the link to application, again, it's in the handouts, but I'm going to put it right here again for you in a second. I just need to find it. It's also
thank you so much as well. This was a great experience. We're very excited about the program, and your team has just been amazing. Everybody's been involved creating this and putting it together. It's wonderful. So thank you.
Thank you so much. I just posted the link to the application. Again, it's on our court's website. It was in your packet, and I'll put our contact information that's also in the handouts today. If you have any questions that didn't get answered or any more questions about the program, please feel free to email us or call us at evictionmediation@18thjudicial.org. And the phone number is 630-407-8807. Thank you so much, everyone.
Thank you, Kim.